The fifth of the panelists is actually my wife. We work together. She's an ethicist, I'm a patent attorney, and our focus is on what should and shouldn't be patentable and how patents should and should not be used. I'm not just here as an accompanying spouse. I actually have worked with Thomas on the Health Impact Fund as well, so I have some credentials. Drugs. Thomas is looking in particular at one aspect of the problems of access to drugs. The fact that there are no drugs for a lot of important diseases. That's covered, at least in part, by the Health Impact Fund. He will speak to you later about that, so I decided we'd have a look more at the dirty tricks department, which is where my professional life has been spent. The barriers, TRIPS, trade-related aspects of intellectual property, was agreed in 1996, and it caused most of the world's countries to agree to allow patents on pharmaceuticals, rather than just patents on processes for making pharmaceuticals. This is important for the drug industry because for a competent chemist, it takes you about 5 minutes to work out a different process for making a drug. So if all there is a patent on the process, it's a worthless piece of paper. And the Indian generics industry was based on that fact because for a long time in India, there were only patents on processes. The same was true, incidentally, in Germany at the turn of the last century, and this is how the German chemical and pharmaceutical industry was founded, by virtue of the fact that they only allowed patents on processes there, but they patented their products in the United States and in the UK, and completely shafted competition over here. Okay, the barriers aren't, in fact, the patents to the pharmaceuticals as such. When a pharmaceutical is invented, you don't normally patent it as a pharmaceutical in every single country, because there are about 170 countries where you can get patents, and it costs you maybe $10,000 in each. It's too expensive at a stage when it's just guesswork. So you tend to cover the more important countries. So the fact that Ghana or Zambia or Zimbabwe have allowed patents on drugs is really not that important. The real barriers are finding someone in the third world countries who can manufacture the drugs at a standard which is reasonable and at a competitiveness that will bring the price down. There's also the problem of regulatory approval. Before you can put a medicine onto the market, you have to get approval. In this country, it's done by the FDA. It's expensive, and it's done on a national basis. And the third real problem is what we do as lawyers and patent attorneys, which is called evergreening. This is a way of extending the legal protection for a drug beyond that was granted by the original patent. My record, patents normally last for 40 years. My record is 40 years, twice the full length of a patent. You can read it. If there are no local manufacturers, you can't have it made locally. You need to go elsewhere, or you need to set up your own local manufacturing company. If you've got a population of 5 million, is that going to be worth it? Especially if they don't have much money. When a company invents a drug, one of the decisions you take within the first year is which countries do we file patents in? Which countries is it worth spending those $10,000 a time in? Well, there are a couple of lists. There are big lists and short lists, depending upon how important you think the drug is likely to be. But at the top of the list is, where is your biggest market? Where are you going to make most money? So United States, Europe, and Japan are at the very top of the list. Then you start adding a few more. The next one you go to is, where can anyone now, or in the next few years, manufacture? So that, for instance, in the past, people could manufacture it in India, and from India they could supply the entire African market, which is a big enough market to make generics manufacture in India worthwhile. So nowadays, what's number 4 on the list? It's India. China's there as well. China's there not just because it's got manufacturing capacity, but because patents last for 20 years, and you're looking towards the profits in 20 years' time. For blockbusters, you're talking at least $1 billion a year. The TRIPS agreement was modified by a General Council decision in 2003, 30th August 2003, which made it possible for compulsory licenses to be granted for export, but under such horrendous conditions that it's really not very relevant. Second problem, regulatory approval. In order to get the drug on market in country A, you have to get regulatory approval in country A, because countries guard their sovereignty. This is absolutely crazy. Countries should say, if it's been approved in US, Japan, Europe, we will rubber stamp it for anyone here. And I say for anyone, not just the original manufacturer, for anyone. So, when it comes towards the end of its patent, we use every technique we possibly can to make sure that the original manufacturer retains all major sales. So, for instance, with the little blue pill that has gone off patent this summer in UK and goes off patent in the United States in 2020, Pfizer have started manufacturing a generic version of it, which they will bring on the market at a massively lower price than the blue Viagra pill. That way, they will attempt to keep competitors away. They have economy of scale. It's going to be a white pill, and they're going to continue selling the blue one because some people will believe that only the blue one works. Why should non-industrialized countries keep paying for the overpriced drug once the patent has expired? In Belgium, for instance, generic substitution of drugs that have gone off patent is exceedingly low. They can't get the Belgians to take the generic version. The doctors like prescribing the brand name drug, the pharmacists like prescribing, handing over the brand name drug, and the patients like it. So the country pays for expensive drugs when they needn't. Once the patent monopoly is at an end, why allow the drug to be sold at a massive profit? Okay, what do we do for evergreening? Data exclusivity, trademark protection. You trademark the color or color combination on your pill. Little old ladies want their red and white pill. They won't accept a white generic alternative. You tweak the formulation and you launch it before you go off patent with the main version, and the doctors want to prescribe the tweaked version. You patent every single efficient manufacturing process, so a generic manufacturer cannot come along and produce at a price which can compete at the level you can go down to if you're in a price war. Use of scale of manufacture is part of that price war. You send out scare stories that the generic isn't the real thing. So, what do we suggest? Least developed countries should accept regulatory approval on drugs from major regulatory authorities, automatically granting local approval to anyone who applies. Because remember, if there's no patent in that country, which there often won't be, this means it's free for generic manufacturers to sell into that country. Number two, and this is one that hurts, allow people to manufacture patented products for export and allow them to be exported. It doesn't affect local sales. Patents are there to promote the benefit of the local public. And sales abroad don't particularly do that. Now, it has to be for all products, not just drugs, otherwise it's not TRIPS compliant. Even if only one country, for example, Cuba, would do this, then they would be able, together with the regulatory approval rubber stamp, they'd be able to supply drugs really low price to most third world countries. Nasty little trick. When you've got a revised version of your drug, you surrender regulatory approval for your original version. Don't allow that unless it was for health and safety reasons. Then just basic ones. Promote generic uptake. Collaborate with other countries. Buy en bulk. Why doesn't Africa buy pills rather than South Africa? TRIPS says there should be technology transfer. To some people, this means letting people read published patent applications. I don't believe that's technology transfer. I think teaching people and helping them establish local industry is tech transfer, not simply allowing them to read the patent applications. And the local elites in a lot of countries are not affected by high patent prices for drugs because they can afford to pay it. They may be partners in the importation firm. Who knows? Just make sure that the decision makers and the elites have no financial interest in continuing inflated prices. Over all of this hangs the cloud of TRIPS. Nothing is permissible if it is not TRIPS compliant. Article 27 of TRIPS says that patents are enjoyable without discrimination to the field of technology, which means you can't put a limitation in place which affects just drugs. It's got to affect all technology. So if you allow manufacture for exportation and exportation, as if you say that is not patent infringement, then you've got to say that for all products. The other is data exclusivity. This business of allowing small country A to rubber stamp approval given in the United States or Japan, that approval is on the basis of data to which the originator has rights. And TRIPS requires the countries to protect that data against unfair commercial use. Well, to my mind, country A rubber stamping FDA's approval is not commercial use of that data. So, thank you.